Hello, once again, this is Antonio, and I'm coming at you with another exciting video. All right, first of all, what we would like to discuss is mom gives birth to a brand new child. Dad says, I had a vasectomy, that's not my child. So, even though you have a vasectomy, there are times where fathers were able to help produce children. So, how do you think this case is going to go? Dad, saying, no, that's not my child, or uh, and the judge agrees, or is this dad's child? So, not further ado, let's dive on into the video.
Several months ago to the little one that you see her holding on the screen. She is not working. She does not have that type of money.
Versus April Porter.
This matter is before the court on the plaintiff's motion to show cause in this matter. Ms. Thomas.
Thank you, Your Honor. In this case, the case scheduling order required the parties to participate in mediation in the month of December. And as it shows on the Register of Actions, mediation was canceled by Mr. Brundage because the defendant did not, in fact, pay mediation fees prior to the mediation. She is in violation of the order of this court, causing failure to move forward with this case. And so we were asking that we could enter a default and then just simply proceed. There still has to be a ROPA hearing in this particular matter, which it could have been done a long time ago, but it still does need to be done. And then we could bring this to a conclusion.
Okay. Ms. Canfield, what's your response?
Thank you, Your Honor. Well, first of all, I very rarely see someone held in contempt of court or sanctioned for having the inability to pay a mediation fee. Ms. Thomas did not contact or communicate with me. If she had, her information in her motion would have been correct or corrected. She indicated at her belief that I had not responded to Mr. Brundage and apprised him of what was happening when in fact I did. And I have an email communication with him informing him that I had relayed the message to my client, and she was going to just contact him regarding that payment. Since then, I have spoken and communicated with my client, who has the inability to pay that mediation fee of $525 right now. She just gave birth several months ago to the little one that you see her holding on the screen. She is not working. She does not have that type of money to pay for mediation. Now, that having been said, I am happy, as is my client, to informally mediate that with Ms. Thomas and her client. But I don't think that, an inability to pay a mediation fee for somebody who just gave birth and is on maternity leave should necessitate an entry of a default judgment. I think that we ought to be able to negotiate this. I believe that the parties themselves have spoken and come to some tentative agreements that Ms. Thomas and I can discuss further and put into a consent judgment of divorce to enter before this court. And I would ask that the court deny the motion and allow us to continue to negotiate to resolve this matter.
What's happening with regard to the ROPA action?
Typically, the person that has the child that is not of the marriage is the one that brings that ROPA action, and it has not been brought by Ms. Canfield. My understanding is that when we were at the scheduling conference, it was actually at the first motion hearing, and another person from Ms. Canfield's office was in attendance. It was my understanding that they were going to be bringing that action, but I've heard nothing from Ms. Canfield since that. Well, and she wasn't here that day. I've heard nothing from her on this case at all.
If she doesn't do it, Ms. Thomas, you're going to have to do it, or there's going to be an order entered, and he'll be declared to be the father. And
no, I understand
that.
And
he can pay for 18 years or more if he wants.
No. I understand that, but when I was told by counsel that they were going to bring it, I assumed that that was going to happen. And I've written a couple of emails to the gentleman, and I've not heard back, so I don't know.
Ms. Thomas, may I ask you who was present at that hearing?
I don't know.
An attorney who's left the office.
It could well have been. I don't know. I have his name in my other part of my file, but I don't have it right here.
Regardless, Ms. Canfield, is your intent to proceed with the ROPA action, or?
Absolutely, Your Honor. We will get that filed.
Okay. My staff says Attorney Crow.
Thank you. That explains things, Your Honor. We don't have the best notations to the file sometimes. So I will definitely get that motion filed, and we'll get that conducted.
Okay, well, let's do that. in the meantime, if the parties wish to get together to resolve the issues, if they feel that they can discuss the matters amongst them and get them resolved, then fine. If not, the court will take the motion, and I will take it under advisement and reserve any finding on that or Ms. Thomas's request for attorney fees in this particular matter, pending resolution of the case.
Thank you.
Thank you, Your Honor.
Thank you.
Your Honor, before we leave, we have a settlement conference this afternoon. Do we need to still be here for that now that with what we've just done?
No, let's proceed. We'll proceed on the ROPA action, and then we can, again, at that point, that might get things resolved depending on the resolution of that. If not, then we'll set it for trial at that time.
Okay.
Thank you, Your Honor. Ms. Thomas, I'll be in touch.
Okay.
Thank you. Goodbye.
Angelique, does your client plan on appearing this morning?
I wasn't certain. I have notified her. She is aware. She did sign a stipulation. I can call her and see if she is available.
We don't need to have her here, Ms. Canfield.
Thank you. Good morning, Judge. Yes,
Good
we
morning.
agree that Ms. Thomas's client is not the biological father, and we've sent over a stipulation. So, Ms. Thomas, did you receive that this morning?
I did not.
Okay, we have emailed it to you. It is signed by both my client and Mr. Ramiro Gutierrez III, who is the biological father, as well as myself, and it has a signature line for yourself and your client. I just wanted to make the court aware that she agrees that Mark is not the dad.
Okay.
Please let me call the case. Calling case 2023-1819 DM, Mark Porter versus April Porter. Today is Monday, February 12th, 2024 at 9:03 a.m.
This matter is before the court on the plaintiff's motion to determine child born out of wedlock. There was some discussion before we went on the record, Ms. Canfield, that she had sent over a stip signed by her client acknowledging that, in fact, the plaintiff is not the biological father. Obviously, looking at the time frame when the last sexual relations occurred and the birth of the child, he possibly could have been. Do we have any DNA testing in this matter?
I don't believe DNA testing has been conducted, Your Honor, but it's my understanding that there was a medical procedure preventing Mr. Porter from bearing any other children with his wife.
Okay.
That's correct.
Yes. Okay. Well, understand that, but let's state in those instances, medical procedures are not always accurate. So the court is going to order that there be some DNA testing done. So court will have the matter done in that manner where we'll have the DNA testing. Once we get that done, then we'll set up for a Wednesday afternoon hearing at that time. So Ms. Canfield, I'll let you coordinate with Ms. Thomas to get the DNA testing done. And then once that happens, we'll set it for a hearing.
Thank you, Your Honor.
Okay.
Your Honor, all right. So do you want an order prepared indicating that is question one? Question two is as far as payment of that DNA testing, is that the defendant's payment?
Yes, I'll have the defendant responsible for that. Ms. Canfield, you may want to check with Mr. Magnuson, and maybe we can get something coordinated through front of the court and do that at a nominal charge.
Thank you, Your Honor. I know that I believe she's residing out of state, so that might be the difficulty.
I think Mr. Magnuson has, we have other cases like that. I'm pretty sure that he can do it through the same DNA test company and still get that better price. So I think that will work.
Okay.
Perfect.
Okay, coordinate that and then let us know when we need to set a hearing.
Thank you.
Okay.
He's the one asking.
Okay, so you clearly saw that mom didn't even bother to show up for the remaining of the case. And in hindsight, the judge just gave her a pass. She don't need to be there. But if dad didn't show up and if dad didn't have proper representation, how do you think that would have went? And also, dad feels that this is not my child. I had a vasectomy, which it still could be dad's child. Eddie Murphy said he had a vasectomy. and he still produced a child. And then with his current wife, he produced 2 other children. So, it is what it is. They tell you when you get a vasectomy, you got to wait a certain amount of time before you get everything out your system. Nevertheless, this is Antonio with Team Tiggio. Please like, comment, subscribe, as we'll be coming to you with more videos in the future. And once again, we will see you in the next video.